in the chronicles of EL, something never happened before, never seen in the world of Telegram learning communities. So today, we unlock the doors to a courtroom where voices rise, truth speaks, and justice breathes. So this is EL Courthouse, not just an event, but an immersive courtroom experience crafted with precision, driven by patience, and made by the learners for the learners. So here, you won't just listen, you will witness. You will witness the justice in motion where every argument cuts teeth and every silence speaks the volumes. So minds will clash, truth will tremble, and the drama obviously will unfold. And by the end, only the evidence and intellect will be there. It will be there till the end as well. So what's gonna happen? What's happening tonight? Let me tell you. So we present to you a full-fledged mock trial played out in a dramatic, intellectually charged format. Here we go with the first round, opening statements. Each side gets 6 minutes total. Okay, even you can say the lawyer, the first lawyer and the second lawyer, both of them will get exact 3 minutes per lawyers. Okay, so this is where the story begins. The initiation, the first round, where each side says their tone, their truth, and their mission. You will get to know very soon. Okay, so 1 minute will be there to break, to breathe, prepare, and raise again, move again. Okay, and the evidence selection round is there as well, guys. So it's more likely. Let me explain. The prosecution lawyers, they will get 2 minutes each. Defense lawyers, they will also get exact 2 minutes each per lawyers. And witness how they present the proof. We will obviously witness and every detail, every proof or evidences that they're going to submit very soon, guys. I'm just explaining what's going to happen, what we are going to witness or experience, something really big. Okay, and in round two, witness examination. Okay, I'm going to explain it. So we are going to have 6 key witnesses tonight. Each side gets to ask 2 questions per witness. Okay, so this is where the real pressure begins, guys. Can they really break the story apart or defend the cracks? This is not the last, guys. We have more. We have still something there. Okay, let me tell you. The last, the round three. The round three is there. The closing statements, the prosecution's main lawyer, they will get 2 minutes per lawyer. And the defense main lawyer as well, they will also get exact 2 minutes to complete their statement. Okay, and the final short, okay, it's a final word. Before I go with it, let me explain the rules a bit. The rules and regulations. Number 1, respect for the court procedures. All the participants follow formal courtroom decorum, including the judges as your honor. Okay. And secondly, the next one, number 2, structured rounds in 4 timed rounds, opening speeches and evidence presentation, witness examination and cross-examination, or even the debate between the lawyers, the verdict announcements. Okay, and the third one, evidence presentation protocol. All evidence, the decorum, reports, exhibits must clearly introduced and also leveled. Okay, and the fourth, this is not the last, guys. Okay, the fourth is the witness questioning. Each witness is it should be both of the sides one objection per witness. Okay, one objection per witness. And the fifth one, objections. Let me tell you. Let me explain it a bit. So, like each side raise, raise one the objection per witness round. I already have told you. And here again we go with the sixth one. Number 6 is fairness and integrity. Honesty is honesty, the testimonies and the arguments here as well in our EL courthouse. And we have two more rules. The number seven, it is audience interaction. Well, observer is for all of you guys. Observers engage with the proceedings, polls and comments. You will be you will get it there in our EL chat box. It's open for everyone. And this is the last one, 8. Okay, the outcome and the verdict. So judges deliberate privately before announcing the verdict. Okay, and all of this will be observed and judged by our honorable judges, Mr. Dinesh Singh and the Saksham. Okay, so it should be. We know that it's going to be firm, fair, and focused on reason and about the reaction, obviously. So, dear audience, don't just watch. Don't just watch. Feel the tension. Wait the evidence and listen to every pause because you are the soul of this courtroom. So let's make this a night to remember. Let the voice rise. Let the battle of word begin. Let the EL courthouse open its gates right here, right now, only on ELVC. Yes, we may go ahead. Yes, D. Saksham, are you there? Please, the stage is yours.
Thank you so much. So, very good evening, everyone. This is your EL Courthouse Judge, the EL Chief, the EL Justice Saksham, with our EL Justice Dinesh. Before we begin, I would like to share in the chat box, everyone, please find the rules and regulation. This is for everyone, the witnesses, the participants, the audience. The jury will be placed among everyone present right now in the EL court. And all the witnesses, all the evidences that are provided will also be shared in the group chat. So please check the rules and regulations for all. Everything will be transparent. Everything will be discussed among the people because judiciary is the keyhole to our democracy and we obey democracy as well. So said so. Also the timing sheets as well as the round breakdown is also shared with you, everyone. Have a glance, have a look. Everything is now among the participants. Before we begin, I would like to call upon and talk about the court here now. So to everyone, the court is now officially in the session. Please follow the rules and regulations carefully to everyone, irrespective of being a lawyer, irrespective of being a judge, irrespective of being an audience or being a witness, culprit, and the justice. I'm the Honorable EL Chief Justice, the Saksham, presenting over this case today with our Honorable EL Chief Justice, Dinesh. Let me remind all present to uphold the dignity and the decorum of this court. Please follow them. This is the matter between the state versus arson involving allegations of a hit and run incident. I'll repeat to the respective judge, the respective courthouse today. This is the matter between state versus arson involving allegations to an hit and run case. The purpose of today's proceedings is to hear the evidences, examine the witnesses, and ensure a fair trial under the law. Now, the counsel, please be reminded to address the court respectfully, avoid interruptions. There will be negations for both the ends, and the court can be immediately adjourned and the session will be upheld if certain amenities are broken in between. Now, the parties will have equal opportunity to present their cases within the prescribed time. Objection should be raised succinctly with proper grounds. I'll repeat, there will be objection rounds for everyone, 2 minutes of open debate between the lawyers from the prosecutor's end as well as from the defendant's end. But do remember this carefully. It should be raised with the proper grounds to it, else it will be overruled. Both the judges will then have to take the action against the parties raising the objections. So everyone, let's all witness the given truthful testimony, and there will be oath undertaken by everyone. The lawyers, you have already communicated to your respective witnesses. Everyone has to call upon the oath which has been already presented to you. Now, at the conclusion of the argument, the court will deliberate and pronounce judgment accordingly. It can be today. If the hearing extends, it might be tomorrow. That will be based on the judges sitting here. Now, the justice will be administered impartially, based solely upon facts and laws. I'll repeat, no emotional concepts, communication, or dramatic order will be taken under this code during in front of the jury. If so, you will be ordered down the witness box if it's a witness, or you will be called upon for your term of speech if it is a lawyer. Any violation of the code, rules, or decorum will not be tolerated, everyone. All the section IPCs and BNSS will be provided in the charge sheet after the court has jurified or been adjourned for the day. Please do not bring any legal basis just between the witness while talking to witness or in the round one. I hope all the laws and all the rules and regulation of the court are now very simplified to everyone. This is something for the first time that we are going to witness. To the audience, witness the truth. To the lawyers, fight the best. To the witness, stay honest, be truthful to yourself. Now, this is the round one. Plaintiff lawyers goes against the defendant lawyers. I would like to call upon the lead lawyer from the plaintiff, the public prosecutor's end. The 3-minute marker for you starts the moment you start speaking. So you may proceed.
All right. So may it please the court, Your Honor, I will have a succinct idea of what happened, the facts of the case. I'm opening the case as next following. On the night of 7th, a peaceful walk turned into a tragedy. A man who was in a car was hit by another car by an SUV. And he struck down that car recklessly. As a result, one of the person was injured severely, and he is still in coma and cannot be presented in the court. So the case further goes like the person arson the SUV car who was driving the SUV car. It's believed, we say that he hit the car and ran away. He fled from the escaped that situation, leaving both the passengers in the car that was hit to fight for their life. So from this case, from these facts, we can say we in law have actus non facitarium nisimens citria, means that a person is guilty when he has a guilty mind along with the act. An act itself is not a guilty, but it is seen as when he has the intention of guilty. Here, actus non facitarium nisimens citria says that when the SUV that fled away from the spot, he was guilty because he hit the car, means he had sometimes the intention. Sometimes it leads to intention. It is but obvious from his action that he had committed this offense. So this is the first. Number second is we have another maxim, that is res ipsa loquitur, means the thing says for itself. The car did not stop to help the car passengers that was hit. So this is another argument that we have here. And moreover, we have evidences that we will be proving in next rounds, like we have CCTV footage that supports our argument. And we have forensic science proof and their report, and another proof that we have is the witnesses. So in the upcoming time, we shall be proving all those points that were confirmed by the forensic science laboratory, by the experts, and we will question the witnesses. Thank you. This was the case.
Okay. Thank you so much, Basit, from the prosecutor's end. So the jury has now noted that it was an hit and run case, and you are upholding the position of the plaintiff, stating arson was the one involved in driving. So the case has been noted. Thank you so much. I would now like to call upon the lawyer from defendant, the lead lawyer from the defendant side, to state their case in the ordinance just now presented by lawyer Basit. So the defendant, you may proceed. You have 3 minutes for your proceedings.
Okay. Before that, can you please confirm I'm audible properly?
Yes, you are perfectly audible.
Okay,
When you
thank you.
proceed with your speech, we will begin the timer.
Okay. May it please the court, your lordship. The prosecution would have this honorable court believe that Mr. Arson, a celebrated public figure, drove recklessly through the night, struck a pedestrian, and fled without remorse. The cardinal principle of criminal jurisdiction says that actus non facet rem nisi mens sed rea, which actually says the act is not guilty unless the mind is guilty. The prosecution must not only establish that the vehicle was involved, but also that this was accused that Mr. Arson was the one acting with inculpable means. But when we peel back the layers of assumptions and examine the evidences, a very different truth emerges. First, I have a solid evidence here that medical report. It is uncontested that after the accident, Mr. Arson bore not even a scratch. I repeat, Mr. Arson bore not even a scratch. The victim tragically suffered severe injuries consisted with high-speed collision. But your lordship, such an impact would inevitably leave marks on the driver. Instead, it was the actual driver, a staff member who sustained a minor fracture in the hand with the sudden impact. The medical report tells the injuries suffered do not align with the person the prosecution accuses. Second, mechanical evidences. The forensic report with a certified private mechanic confirms that the superficial damage on Mr. Arson's vehicle is inconsistent with the grievous injuries described. The physics of the collision, speed, force, and body impact do not match the way it is described. This directs that despite driving with limited control of speed, the collision was hard. But due to the SUV, it was protected well. The driver inside the SUV and the person who was instead in front of the SUV was suffering with a heavy injuries. For the third testimonial evidences, according to the testimony of Mr. Hirsch, a police officer, he reached the scene at approximately 2:30 a.m. The victim was admitted to the hospital only at 4 a.m. This timeline is crucial. Why? Because at precisely 2:15 a.m., I repeat 2:15 a.m., Mr. Arson was at home on a live video call with his manager, Miss Moon. They were planning for the upcoming shoot, which clearly said by the call log report as verified. For the fourth and the very conclusive evidence, I would like to state that the driver's testimony, which already described that the driver was driving the car. And he also said that he was the first one to inform the officer about the accident and also coordinated with the officer and helped in the medical.
Okay. So thank you, counsel. The court has also noted your part of submission. It was simply stated from your end that arson, the supported culprit of the idea, is not the culprit. It was the driver. You also stated that there is a written testimony which will be displayed later to us as well. So court has noted your submission. Thank you. The arguments have been heard and are duly recorded from both the sides at this time. Now, let's learn what evidences the counsel has brought to us today. So there is a 30-second break given to both the sides now. Please do finalize all your evidences. Do share it with the jury. Also do share it with the audience on the main chat. So Mr. Ram, the supporting lawyer, and Ms. Video, the supporting lawyer from the defendant, you may now proceed with sharing your evidences in the group. I repeat, all the evidences now can be shared. Please do mention what your evidence is about. And
Okay.
then we can begin. Yes. Let me finish, Mr. Ram. Duly follow the court's rule. Yes. You may proceed with the evidences. Later on, in next round, both the supporting lawyers will be called upon and they have to describe the evidences one by one. I'll repeat, both the lawyers, the supporting lawyers from plaintiff and defendant respectively, will later be called for expressing their views on the evidences and how they are being brought up. So please do share the evidences now.
Yeah. Sir, Your Honor, can I start?
Ram will begin with you. Please first share the evidences. So evidences will be shared in front of the audience, being the prime witness to our real courthouse, in all conscious to the judges, in all conscious to the audience. The evidences will be recognized as the key point to the next witness round and to all the hearings by this time. I'll repeat, all the hearings by this time will be now judged over the evidences provided by the plaintiff, the public prosecutors, and by the defendant. Please do follow the rule and share your evidences now sincerely. And Mr. Ram, you may proceed with your evidences. Do state what evidences you brought in front to the court and do state that how you obtained that. Thank you so much. You may proceed now.
So, Your Honor, very respectful. Yeah, who's there? So, Your Honor, so I have some evidences regarding that how Mr. Arshan hit the car of my passenger, my okay. So the first evidence we have is CCTV footage where you can clearly see that how a small vehicle was hit from behind by by a white color lube SUV, and the SUV was coming with very high speed as you can see in the video, and after that no one stops. They just moved away from the that is from the CCTV footage it is shown. The second evidence from our side is the first information report FIR which was registered at 2:50 a.m. On 6 September 1925, and this FIR is telling a very great information regarding the accused. It has mentioned about that who was the accused, who was the car name of the accused, what was the number, and and okay, and it also tells about the victim. He was a driver, he was a delivery worker, and he got a high injury. That is what the FIR talks about. And the third evidence I want to share is the medical report which was prepared by Dr. Nandan. And as you can see the medical report, uh, it is talking about severe blood swelling which our victim faced, and afterwards we are having the forensic report of Mr. Arson's uh, car, and here you can see that the footage of a white colored SUV uh, white colored SUV, white colored SUV, and this evidence talks about that how it have this evidence talks about two things. The first, the dent patterns of the vehicles is consistent with the damage of the victim's car. It shows that collision happens and it was done by the the dent patterns. Sorry, the vehicle which was the this SUV. And the second things it talks about is that the SUV was there in that side using the evidence of the tires. The 8 HV SUV tires were there. Their impression was found at the location of the south side. So this is my report. Okay, I'm sharing. And then uh, yeah, these are the reports which I had, and I have shared all of them. So now I want the judges to think about it.
Okay, Ram. First of all, the court directs both the parties to please adhere the time limit. The court won't take any excuse if you leave the time, elevate the time more than 2 minutes. There are more hearing pending after it. I hope that mentions and that clears the doubt in disguise then. I would like to repeat, I have been provided with one forensic report, and so the audience. I have been provided with one medical report signed by Dr. Nandan. I have also received one FIR, the first information report of the victim, and I've also received one image of the CCTV camera by the prosecutor's end. Now the exhibits are admitted to the evidences and now provided to the court. The court will take a good glance over it, and in the meantime the audience can also do the same. And said so, I would like to give the opportunity now to the defendant to provide your sort of evidences and the regarded speech in the court. So the defendant lawyer, you may proceed with your evidences and the proof to it. You may proceed now.
All right, Your Honor. Am I audible?
Yes, you are perfectly audible. You may proceed now.
Your Lordship, the defense respectfully submits four crucial evidences before this honorable court, each of which independently and collectively proves Mr. innocent of the allegation. First, the medical report. Neutral, biased, and states that Mr. bore no physical injuries. If he had truly been involved, alleged collision, injuries, bruises, or trauma would have been unavoidable. The complete absence of such injuries shows beyond doubt that he was not physically part of the. And second, the call logs and the tower location records and the screenshots. The official telecom records are beyond manipulation. These show that at the exact time of the alleged incident, Arson was on active call. The tower data places him in a different part of the city, far away from the crime scene. This is not an oral claim, it is scientific digital proof that cannot be altered. It provides him with a strong and reliable alibi. And the third is the police testimony. In cross-examination, the investigating officer admitted that the place between 2:30 a.m. to 2:45 a.m. This timing matches exactly with the telecom data. That proves Arson was on call and he was not at the crime scene. And the fourth one, FIR. Itself contains gaps and inconsistencies, which we will highlight to show that the prosecution's version is unreliable. Your Lordship, when we look at these four evidences, therefore, I believe the defense humbly submits that these evidences together leave no space for doubt, suspicion, or conviction.
Okay. So the court has already again been directed with the prosecutions as well as the defendants, presented counsel, investigations as well as the evidences. But the court would like to call upon Ram again from the plaintiff side to please present if there are any testimonies provided to you, regardless of the victim, the witness who couldn't present in the court today. I'll repeat, Ram, from the prosecutor's end. Please do repeat if you have any testimonies with you for the one who are not present here today. Please read it in a format that, Your Honor, this is person who has written the testimony lying under the case. You may proceed, Ram. And my
Yeah.
humble request to you, Ram, please follow the court's instruction. Ahead of this, we won't be expecting any other insurgencies. It will be simply marked as a way to discreet the court. When you're asked, then only please speak. Thank you, Ram. You may proceed.
Your Honor, and I will do follow the rules of the court. The testimony of the victim, the person who was driving the car, himself has submitted a testimony where he reveals that he was hit from behind by a large SUV, and that the SUV driver never stopped after that, and he was um hurt very badly. That was his testimony, and he is seeking justice for the harm which is caused to him. And he wants that accused should be held responsible and they should be punished. Yeah, this is from my side.
Okay. The court has again adored the presented testimony. The testimony is presented by the victim, the anonymous driver who got hit. So thank you so much, Ram, from your end. I would like to ask the proceedings from the defendant side as well. Please provide us with the testimony given from, if any testimony provided to you, please present it to the court now or hold it forever. So Weirdo, from the defendant side, proceed if you have any witness.
Yes, Honor. I have the testimony from the driver. I'll proceed. Lordship, I am the driver responsible for Mr. Arthur on the night of September 6, 2025. Driving carefully through the streets of Bandra when suddenly a small car soared abruptly in front of him. Despite immediately stopped, checked on the other driver help, Mr. Arson was not behind the wheel at any point that evening. He was at the residence. He
Lawyer Weirdo, the court now extends its regard for you to please repeat the duly noted evidence testimony again because your voice was not audible. So I'll ask you again, please repeat it, else you can share it in the section for us to read it once. I'll repeat, the proof of upheld again, else if you can't, please share the chat. You may proceed.
All right, just allow me a moment. Here is shared in the group. Kindly it.
Okay. Thank you so much. You may proceed to your stands. And now the court has received all the proven evidences with the proofs, with who brought the proofs in, what witness states they provide. So the court will extend its gratitude to both the sides for maintaining the decorum by this side. And we shall now proceed with our next part, the next round of this court. So the witnesses will now be called upon from each counsel. The arguments by this time have been heard and duly recorded. Now let's record and show that the learned counsel has concluded their statements. And following to that, we will now proceed with our next stage of hearing. The court now acknowledges the point raised by the learned counsels. So the plaintiff have been pressurizing the fact that arson is the one involved in the hit and run case, where the defendant has provided us with enough evidences to prove that it wasn't arson. But the submission will be considered along with all other evidences. Now the burden stays on plaintiff and the defendant. So counsel, you may step down now. And to step in, we would like to call our first witness. We'll begin with, that is the Sub-Inspector Harsh Rawat. I'll repeat, Sub-Inspector Harsh Rawat, you may step up to the witness box. This is how the proceedings will be done from your end. Please begin with taking the oath preliminary given to you. The court appreciates the detailed argument put forth from both the sides. Hereby, plaintiff will begin with their questions first, adhering and substituting to the sub-inspector, and later on, the defendant can move ahead. I'll repeat again, Sub-Inspector Harsh Rawat, you may step up to the victim box now, to the witness box now, and both the sides will then ask the questions, beginning with plaintiff and then to the defendant. Only and only one objection will be raised from both the sides. If raised, then there will be a 2-minute of debate round from both the sides. I'll repeat, if and only if the objection has been raised and objection has been permitted, resumed, then only the debate for 2 minutes will upheld from both defendant and plaintiff. Harsh Rawat, Sub-Inspector, please join in to the witness box.
I solemnly affirm that I will speak the truth, the whole truth, and nothing but the truth. Your Lordship, I am Inspector Harsh Rawat, Bandra Police Station. 15 years in uniform. I have seen my share of accident scenes, but this one caught my attention the moment I stepped out of the jeep. It was about 2:30 a.m., Linking Road, quiet except for the flashing hazard lights of a bystander's car. The pedestrian was lying near the curb, badly injured. His car had taken a direct hit. The bonnet crumpled like paper. The road told its own story. Long skid marks, shattered glass, bits of bumper, everything pointed towards high-speed impact. And yet, no driver, no car. The silence was my first clue. A genuine accident. The driver usually waits, panics, shouts for help. Here, nothing. That's when I knew we were looking at a hit and run under section 106.2 of BNS. I secured the area, called for an ambulance, and started putting the pieces together. The FIR Exhibit 1 captures it all: date, time, location, witnesses, and the first description of the vehicle, a white luxury SUV. Later that night, we even got another FIR about reckless driving from the same car number. Minutes before the accident, that was not coincidence, that was pattern. Then came the CCTV footage, Exhibit 2, grainy, yes, but clear enough to tell the tale. A white SUV blazing down the road, swirling, hitting the parked car, and running. The license plate, partially visible, matches the accused registered vehicle. The timestamp fits perfectly with the timeline. The direction of escape, straight towards the accused neighborhood. So, to put it simply, it was no ghost car. It was a driver who knew what happened and chose to vanish. That's the evidence I placed in this court, my lord.
Okay, so the court has now heard Sub-Inspector Harsh Rawat. You may still step up. Now the counsel from the plaintiff side may begin asking the doubts. I'll instill this again. There are 2 FIRs registered from your end. One on the moment of incident, one after the incident by the driver. You may confirm it, Sub-Inspector Harsh.
Yes, my lordship. So the first incident was which I noticed when the car hit and run. And second one we got later at night, but that second one incident was actually before the hit and run case. because someone lost the FIR very later on because the person was on his way to his work. And once he got to his work, then he called us and told the whole story.
Okay. So the witness has been excused from the jury. Now the cross-examination may proceed. The counsel from the plaintiff, the public prosecutor, you may proceed with further questioning. I'll repeat. The witness has been excused, from the jury. The testimony of the witness has been recorded. Hereby, the cross-examination can be proceeded by the counsel at plaintiff. Ram, from the plaintiff, you may proceed with the cross-examination.
Okay, thank you, Your Honor. So my first question I want to know to the police officer that inspector, based on the FIR in Exhibit 1, what specific details indicate that the driver knowingly fled the scene without providing it?
Your Lordship, the road was lit up. Street lights, open shops even at that hour. Witnesses around. The impact was hard enough to leave debris all over. Any driver would have known that they have hit something. Yet, there was no call, no stop, no report. The FIR reflects all. In my experience, when someone drives off like that, that's not ignorance, that's a choice.
Okay. Regarding the CCTV footage, uh, still in Exhibit 2, how do they link the vehicle directly of the accused? How can you say that it was of arson?
Your Lordship, the stills gives us three solid things: model, color, and partial plate. All three matches the accused vehicle. The footage also shows the car heading towards her known residence. We double-checked the RTO database. No other similar vehicle was reported in the area that night. This is not just a coincidence. It's corroboration.
I have to ask just these two questions.
Okay. So the court has heard the cross-examination questions as well. The court has also recorded the testimony heard from Sub-Inspector Harsh Rawat, and that is under the consciousness and informative of the entire audience sitting with us in the court. So let us record and reflect the witness that has remained the cross-examination. Now I will recall it again. That was just the counsel of plaintiff. Now I will like to call upon the counsel from defendant to proceed with their cross-examination, regardless of what examination has been done from the counsel of plaintiff. So from the defendant, you may proceed with your cross-examination questions to Sub-Inspector Harsh. And objection motives are still open. So to both the counsels, you can object to any further proceedings and hearings hereby. So counsel of defense, you may.
Yes, I have few questions for the inspector. So, inspector, the CCTV video in Exhibit 2 looks very blurry when you want to look the face of the driver. Isn't it true that you cannot clearly see who is driving or confirm if it is really my client, Mr. Arson?
Blurry, you mean grainy, right? Sure, but even grainy footage can't hide a car's mistake, model and color. Not when you enhance it frame by frame like we did with our advanced technology. And the plate, we matched what we could read. And it lined up exactly. There were not 10 white SUVs in Bandra doing 100 kilometers per hour that night. There was one, and it was this car. I can tell it by my expertise.
All right, but still you cannot see the face of the driver. This is my question.
For that, an independent motorist, someone completely unrelated to
Objection,
the victim,
Your Honor,
yet
objection. I have an objection here. The police officer, the honorable police officer is
Objection
confirming that
overruled.
Let them continue, please.
All right, so
Thank you. Yes, Inspector, you may continue.
Yeah. So I was telling that a famous YouTuber who also do motorcycling uploaded a video which was shared to the court as well. Someone completely unrelated to the victim was the one who recorded it. He was blocked on the road by the same SUV just minutes before the accident. He even provided a dashcam clip which was submitted already. That's part of the file. When two strangers tell the same story without knowing each other, my lord, I tend to trust the pattern.
Thank you, Inspector. I have another question for you. In the second FIR, you added a charge for rash driving and blocking the road. Who gave that report?
The figure is public, but in order to just safeguard his identity, because he's really a big figure, he asked us to do not reveal his name. But if the court requires, I will do it.
Thank you, Inspector. So, Your Lordship, it's very clear that even in the CCTV footage, although we can see the model of the car, but we can still not confirm whether my client, Mr. Arson, was driving. So, you may continue.
Okay. The court has restrained all the examinations by this time for in regards of Sub Inspector Harsh. Objection can be sustained now from the counsel of public prosecutor, the plaintiff Basid. Basid, you may now sustain with your objection, and then the court will decide will the objection be proceeded ahead. Basid, you may sustain it.
all right, so the inspector clearly made it stark to my adversary, to the counsel of defendant, that model was revealed, that the fancy number plate was revealed, everything related to car was revealed. Now she is trying to get the size of this accused person. She wants to make it like a mechanical evidence. This is not a mechanical evidence, this is substantial evidence. Mechanical evidence can have no objection because the model in itself, it has zero, almost zero human bias. Why? Because the model was clear to her, it was clear to the court that model was same, everything was clear to them. Now she is trying to manipulate the police officer by saying, could she exactly could he exactly identify who the accused was? Now if the inspector also confirms that, she will go further. She's creating totally, I think, assumptions that whether this happened or that happened. The CCTV footage, although it was grainy, it clearly shows it was a model. What is the question of raising that whether he saw exactly who he was? This is, I think, out of context.
Advocate Basid, the court has already sustained the cross examinations, but Advocate Weirdo, you may continue responding to the questions uphold against your client. So we will be giving 2 minutes to both the advocates from both the counsels, Basit and Weirdo. The next 2 minutes can be an open, non-moderation discussion between Basit and Weirdo from the defendant and from the prosecutor. But do remember, the discussion should lie under the limits and the decorum of the courts. So, Basit, you may proceed with a question. Weirdo, you may proceed with your response to it, and so on and so forth for 2 minutes. The 2 minutes
All
of
right.
non-moderation starts now.
All right. So, Veeru, my question to you is, you are my adversary. You said that tower trace and mobile call logs, these are the proof that he claims the plea of alibi. So I would say that call logs, although they were not traced around the location, that is not a conclusive proof that it was not arson. Because a mobile phone, it does not mean that you always carry your mobile phone with you, or the SIM is registered in your name, or whatever it is. It is not a conclusive proof. It is not the only proof by which you can say it was not arson. I told you only the reason already. So number second question to you, would you care to explain this next? And number second question to you is, you said no injuries happened to the other person, to the other passenger. What you want to say to the court, that was not it a fortune? Are you saying this is a misfortune that other person was saved? There are accidents where five persons get killed and only one is saved. And that is totally fortune, I would say, that other person did not get injury. So, would you please care to explain these things?
Okay, I would like to discard all the false claims because first, I would like to address the first question. You said that mobile phones can be elsewhere, but the point is the tower location records are the official telecom records, and these are beyond manipulation. And Ria Kapoor was on the call. It's manager of Mr. Asen, and she shared it, and we'll have in the court, and she'll also answer the same thing, and we'll see that. And about that, I did not say that it was a fortune or misfortune that the other person got saved. I did not say it. When I claimed that my client, Mr. Arson, did not get any bruise or any injury, I was not pointing out the driver because he was not driving the car. He did not get any bruise because he was not there at the incident. He was in his home, very far from the crime location. He was on the phone from 2:30 to 2:45 when the incident took place. So your allegation is totally false. When it comes to the evidence, you can have a look at it.
You did not get my question. My question was, the tower trace mobile call logs does not mean that you always carry your phone with you. This is my question. And number second, you said that Arson did not get any bruise. You can see in which vehicle he is sitting or she is sitting. It's a luxurious car. It is a heavy car. I would say a fancy car. Um, there are less chances of, I would say little chances of getting injury in that car.
All right, even if you do not carry a mobile phone according to the report, but still he was on the call. And even if he was on the call and he met with an accident and hurt the other person, he would get some bruises or any injury. Don't you think so? But he didn't get. It clearly shows that he was not there at the crime location. Your victim got injured and he was in hospital and everything happened, but why my client is not injured at all? It cannot be a miracle.
Time and again, I'm repeating you that mobile phone could not be with Arson. He may be sitting in the car, but his mobile phone or her mobile phone could be somewhere else.
How can you prove it that his mobile phone was not with him? They are clearly video recording. And
Order,
Mr.
order in the court. Both the proceedings have been heard. Thank you for mentioning under the non-moderated part of the court that yes, the answers were provided and has been recorded from both the side. Do said so. Please maintain the decorum of the court. Once the held has been done, please stop. Okay. So, Harsh Rawat, you may step down from the witness box. The court will excuse you from your witness now. Moving ahead with our next neutral witness. Since mentioned, the evidences are provided as the medical reports. I would like to call Dr. Nandan, a medical specialist physician, to step up on the witness box and please proceed with your witness points, and later we will follow the same fashion at the Yale Courthouse to follow up the cross-examination beginning with the plaintiff. So Dr. Nandan, you may join us at the witness box. Dr. Nandan.
Yeah. I
Thank you.
solemnly
Please
affirm.
maintain Please maintain the decorum of the court. Once asked, do join. And please begin with your oath and then proceed with your hearing. Back to you, Nandan.
I solemnly affirm that I will speak only the truth, the whole truth, and nothing but the truth. Your Lordship, I am Dr. Nandan from Leelavati Hospital, Mumbai. I was the attending physician for the victims involved in the hit-and-run accident on September 5, 2025. As per standard procedures, all we know, I prepared two medical reports based on examination conducted immediately after the incident. The first report, Exhibit 3A, details the pedestrian victim's injuries: a male delivery worker admitted at 4 a.m. with severe head trauma, including a fractured skull, brain swelling, and multiple lacerations from vehicle impact. He remains in coma with a prognosis of potential permanent disability. The report includes X-ray treatment notes and my certification that the injuries are consistent with a high-speed collision exhausted by delayed medical aid due to the driver fainter. Second report, Exhibit 3B, covers a minor injury on the hands of individual claiming to be the driver, a chauffeur associated with the accused vehicle. This includes abrasion, bruises on the palms and fingers, not requiring hospitalization, consistent with gripping a steering wheel during a sudden impact. Both reports are certified with hospital stamps, dates, and my signature as required for claims under the Motor Vehicle Act. Thank you, my lord.
Guaranteed, Nandan. We have received the witness evidences from Dr. Nandan with your signature. Now both side of the council has their evidences proofs. For the audience to verify and cross-section, for the cross-verification, you may check our English Learners channel. You will find the evidences of both the medical reports there. Now you're excused from the jury. Now the testimony of the witness hereby has been recorded. We will now proceed with the cross-examination. The counsel at the plaintiff, hereby with whom you may begin a cross-examination with Dr. Nandan.
Okay, so Your Honor, my name is Ram, and I want to ask one question to the doctor. That Dr. Nandan, based on the pedestrian's medical report in Exhibit 3.A, how did the delay in aid? How did the delay in aid due to the hit and run worsen the victim's severe head injury? Can you answer this one?
Your Lordship, the report shows that the head trauma caused immediate brain swelling. Without prompt aid from the driver, the victim lay unattended for over 30 minutes, leading to complications like reduced oxygen flow. This delay turned a potentially treatable injury into a coma, as noted in the certified notes.
Okay, so regarding both reports, do the injuries in the Exhibit 3A and the Exhibit 3B collectively indicate a high impact collision consisting with reckless driving?
Yes, the pedestrian's severe fracture in Exhibit 3A aligned with a vehicular strike at high speed. The minor hand injuries in Exhibit 3B suggest the driver experienced jolt from the wheel, but the overall pattern points to negligence in not stopping, worsening the outcome.
That's all from my side. Now I'm satisfied. Over to the court.
The court has recorded the cross-verification and cross-examination questions from the plaintiff. No objection raised. Said so. Moving ahead now with the defendant. Defendant with the thumb, with the gravel, you may begin your examination with the doctor.
Yes, thank you, Your Honor. So, Dr. Nandan, looking at Exhibit 3B, the hand injury report, don't the scratches and the bruises on the palms show that the person was tightly holding the steering and the wheel during the crash? Isn't that more likely for a train driver like a chauffeur rather than my client who is an actor and not used to driving?
Can I object?
Eh,
I want to object, Milo. So my objection is that is the sorry, no objection.
Could my adversary, could I ask this honorable court to please tell the adversary to come again at this point?
The court
Surely.
has no-
So my
the court has noted the mismanagement from both the side. This is one final warning given to both the counsels, stated Ram interrupting the response and examination of Dr. Nandan. Please do remember the court is recording the hearing. Every word is been recorded for final jury and jurisdiction. I'll once again state this to both the sides. Please do not interrupt between. Stated Nandan, Dr. Nandan, stated the counsel member from the defendant. Please proceed with the question again. And please object
thank you, Your Honor.
please object after the end of the speech. Yes, you may proceed. Defendant, Lon.
Thank you so much. So my Dr. Nandan, I hope you can hear me.
yes, yes.
All right. So my question to you is, if you look at Exhibit 3B, the hand injury report, it clearly shows someone who is holding tight that steering wheel, someone who is very good at driving. But my client is not a trained driver. It's more like a chauffeur, the person who got the injury. So rather than my client who is totally an actor and not used to driving, what do you think about it?
Your Lordship, the abrasions are consistent with gripping a steering wheel during impact. While I cannot say with 100% certainty who was driving, the injuries match someone who had their hands firmly on the wheel at the moment of collision.
All right. And in Exhibit 3B, the chauffeur was examined at 4:15 a.m., if I'm not wrong, right after the crash. And since the hand injuries were small and fresh, doesn't this prove he was the one driving and went for treatment quickly, which clears my client?
Objection, Your Honor. Objection. The police officer already has told the court that it was a hit and run case. He hit the car, he hit the person, and then fled from the scene. So this is extraneous question.
Objection sustained. The counsel from the plaintiff and the counsel for defendant, the court would love to hear the objections responses from both the side. Hereby I order the court, the justice orders 2 minutes of contention to view the opinions on the objection raised. Basit, Advocate Basit and Advocate Viedo, your 2 minutes to not only address the objection but to respond the same. Starts the moment you begin with your answer.
So Vero, if you see the doctrine of res gestae, that is a series of transactions, the police officer has already made it crystal clear to the court that it was a hit and run case. He did not have time to see who was injured in hand and everything. So is the case with forensic experts because they were not present on the scene. So what's your take
Of
on
course, my take on this, that in this video it's like clearly visible that it was front collision, and along with the officer's statement of bumper, and also the driver was there in the hospital at 4:15 and the palm injury was fresh. Even if though it was a hit and run case, still people need to, recover from the injuries that they got. So how does it prove that it was my client? And how does it prove that even if it was a hit and run case, that the person would not go to the doctor?
All right, thank you very much for proving my point. So I would like the Honorable Court to please take notice of this. First of all, at the very outset, at the very beginning, the widow, my adversary, was denying that it was not her client. Now she has admitted that it was his client who hit the car.
When
Now
did
this is
I when did I admit? You are misinterpreting what I've said. I said it was not my client, it was the person who got the injury in his palm and he just went to the doctor.
now if it were another person, if I take your point, if it were another person, what you have to do with that? You simply
The
had to
person
prove
itself filed the
that
FIR.
you simply
It
had
was
to
not my
prove
client.
you simply had to prove it was not your client. But you are mentioning this thing now. You are mentioning that FIR is correct. It was the FIR was against a specific car, and that the model of that car, the fancy number of that car was already visible in the CCTV footage. It was clear to the court at the very beginning. So first of all, you said that it was not your client or whosoever it was. It was not his car. He was playing an a doctrine of alibi. Even if it was his driver, still your client is this responsible. Still he is liable. Why? I will tell you. In law, we have a maxim. I would like to the honorable court to take note of this. In law, we have a maxim called respondent superior, that even if a servant, even if an agent does anything that is against law, still the superior, still his master, still the principal is liable. Why? Because he's working for his benefit. He was in the course of his employment and all those things keeping into consideration, still the master is liable. Still arson will be liable because it was his car, it was his driver, he was working in the course of his employment, he was employed by arson. This is number first.
Basit,
Number
when did
second
I
is
say it was my client's driver? I did not say it was my client's driver. I just simply said the driver, the person who was driving the car. It was as simple as that. It did not prove that it was my client's driver. You are misunderstanding whatever I'm saying, trying to prove your point so desperately, which is
all right,
very wrong. And
all
also,
right,
even if it was my client's driver, which is it's not, but let's suppose it was my client's driver, still he got the license of the particular car. My client was not present at the moment. You cannot prove it was my client's driver since he was not.
Order in the court, the gavel of justice. Thank you. The court has heard both the sides of the argument stated from the plaintiff Basit as well as from the counsel at defendant. I will reinitiate the witness examination. Please continue the defendant, Advocate Weirdo, with Dr. Nandan, if you have any more further questions to ask. Since there are no more cross-examination conducted from the defendant's side to our witness, Dr. Nandan. Dr. Nandan, you may step out of the witness box, and all the courtroom has mentioned as well as recorded your examination. Now the court would like to call upon our next witness. Hereby, the witness are being provided from both the sides of the counsel. So, the court now requests the plaintiff public prosecutor to call upon your chosen witness for cross-examination. The witness may enter the witness box. Please do respect the decorum. Describe your jury here, and prosecutor may begin with the questions. I'll repeat. The public prosecutor, counsel, you may bring up your first witness to the witness box. Advocate Basit, Advocate Ram, you may call your first witness to the witness box. The court won't wait anymore.
Yeah. So my first witness is the eyewitness, and the name of the person is Rhyme, and who has saw this whole incident happening from her own eyes. So Rhyme, are you there? Please step up and come to the. Hello, Rhyme, are you there?
The court has revoked your announce for the witness. The jury, the counsel at plaintiff, would you like to call upon any other witnesses to the witness box? Else we shall move ahead to the counsel at defendant.
We have another witness, which is forensic expert, Mr. Nikhil sir. Are you there? Mr. Junior. Junior, are you there?
Yes, I'm here.
Yeah, please tell the court that what your being an expert in forensic, what your research, what your understanding tells.
All the excellencies to the Court of Justice, my lord. I solemnly affirm that I will speak the truth, the whole truth, and nothing but the truth. Your lordship, I am Nikhil Vyas, a forensic analyst with the Mumbai FSL. I examined evidence from the hit and run scene, including paint chips from the victim's clothing and damage on the accused's white SUV, my lordship. My report, section Exhibit 4, shows a direct match, confirming the vehicle was involved in the high-speed collision. No mechanical faults were found, indicating driver error, negligence, and rupture. That's my testimony, my lordship.
Okay, I have some questions. I have some questions to you.
Order in the court.
So, Mr. Nikhil, what does your forensic analysis in
Order
expert
in the court, Mr. Ram, Advocate Ram. I hope I was audible. Yes. Dr. Nikhil, we have recorded, the court has recorded your testimony and also your evidences regarding the issue of the case. Now, Advocate Ram, you may proceed with the cross-examination regarding your case.
Okay, thank you, Your Honor. And I have one curiosity I want to know about from Mr. Nikhil, that what does your forensic analysis in Exhibit 4 reveals about the vehicle's involvement in the crash?
Your lordship is speaking the truth. The paint chips from the victim's clothes chemically match the SUV's exterior, and the dent patterns align with the impact angle. This proves the vehicle struck the pedestrian at over 80 km/h with no evidence of braking, showing complete negligence in driving errors.
I have one more curiosity. How does this evidence demonstrate that the accused negligence to the hit and run? How this evidence proves that accused was negligence and in the hit and run?
My lordship, the lack of skid marks or mechanical defects in the report shows the driver could have stopped but chose not to do so. The debris trail indicates they fled immediately after impact, worsening the victim's injuries through delay. There's one more thing, lordship, I want to figure out here and point out to the Court of Justice. Lack of skid marks. Skid marks means the driver likely did not brake at all, and speed was more than the regulatory authorities of the traffic rules of our Constitution of India. So it has completely proved one fact, that the debris was spread all over the scattering road on the side of the streets, and at the same time, a complete damage in a very deeper manner has been proven by our forensic evaluation of the report.
This is all from my side. Now I don't have want to ask any more question. Over to the
Yes, Ram, we have noted, the court has noted the responses from Dr. Nikhil. Now, the court will extend its cross verification from the jury, from the counsel of defendant. From the counsel of defendant, Advocate Leaf, you may proceed with your evidence, your investigations.
Okay. So Nikhil, like forensic sir, I want to ask you this thing that can you tell me what would be the angle of collision between the two cars?
Angle of collision between the two cars was 135 degree.
Okay. And here comes my second question, that do you think that both the cars need to be in the same speed, or maybe one need to be in a higher speed and comparatively another one need to be in speed to get into this much collision where the victim has suffered this grievous kind of injuries?
Sure. Well, in order to sustain the same injuries, as per our report, when one of the cars was highly driven and the second vehicle was not highly driven, so the kind of injuries and the debris trail on the road our forensic report has found that completely depicts and demonstrates this thing, that the car of the person who is right now accused in the case, Mr. Arson, was driving the car at a very high speed.
Okay, you said Mr. Arson was driving the car, but I think there are no specific evidences which are there. But since you said this thing as well, that the car should be in a similar speed or higher speed, and since SUV is well protected and a heavy car, it means a smaller car will have more larger damage than a car which is heavily protected, right? Even if they are in the same speed. That is what you meant, I assume.
No, I have already stated one thing, that both the vehicles were with the different speed tracks. This has been clearly mentioned by our report. And secondly, when I talk about the angle, so when two vehicles are colliding with each other, it's not only about the collision itself, but it is all about the kind of the angle that the collision brings. If both the cars, they are colliding with each other at the angle of 180 degree, let's say, or 45 degree or 90 degree, then the collision would have injected into a very, or infused into a very bigger injury to both the sides. But since it was not possible due to the different angle of the collision.
Okay. With the like, while hearing, I can assume that there was an accident, and while listening to you, I can presume that the car were in high speed, but this does not prove by any chance that Mr. Arson was the one who was driving the car. Thank you so much.
Well, thank you. I could state one thing here, that if you talk about the range of the vehicle, it was 80 km/h on an estimation. Even if you reduce, if you reduce this estimation by 10 km/h, or even if you increase it, still it was more than the margin that the vehicle authorities have provided to people on the same street to drive. So it was a complete case of hit and run. And secondly, the vehicle was driving at a very great speed. And that not only has been proven by the kind of braking system which was not used there and the kind of injury the another person has sustained, but it was also proven by the debris trail. And that shows that there is a chain of debris on the road itself that depicts the angle of the sustained injury to the another vehicle, and also at what speed on an estimated report was the vehicle was being driven.
Okay. Since you mentioned additional information, I just want to ask you one more question here. Since the collision was this big, and you stated that the person need to be in high speed, like one car need to be in high speed, that means the person need to have very good control over the car to get as less damage as possible, especially the one who is driving rashly. Let's assume that Mr. Client was the one, according to the prosecution.
Objection, Your Honor, objection.
Objection sustained. You may continue with it.
She herself said that she is assuming something. Law does not rely on assumptions. It is based on facts and the law. So don't create, I would like my adversary to not to create assumptions.
I would like to say this thing that your whole case is running on assumption. You don't have valid supportive evidence where you could claim that it was Arson, Mr. Arson, who was running the car, right? Even the one who saw the sole witness who was there was 50 meters away in the dark. So you cannot assume that it was Arson, but since you said about assumption, I'm giving you that valid answer here.
So I would like to say on this point that your mechanic was also standing there. He was also on specific, not very near to the incident. He was also at some distance. You cannot say that my witness did not see it very clearly. What I am saying is you are creating assumptions. I never created any kind of assumption. Why? Because the CCTV footage itself says that the model of the car matches with arson, that the car number, everything, and more specifically the chips of the paint that are present on the clothes of the victim, those stains, those strips of the paint, they match with arson's car.
Okay, I here want to ask you one thing. Do you use car, by the way?
Everybody knows, yes.
Yeah. So you are are you the only one who drives the car? Or are you the only person who goes to your office or anywhere? Does your father,
That's
your
the,
brother, your sister doesn't use the car?
I like that question. Means somebody from my family, somebody from my relatives, my friend, or my driver is driving the car, not anyone else, not a person, not a third party. I know the person, but that vehicle is registered on my name, means it belongs to me. More specifically saying, most of the time I drive my vehicle by my own.
So
It happens
indirectly, you
rarely.
want to say that you already know it wasn't arson, but it was somebody else. But you want Mr. Arson to take responsibility for the act the driver has did. Okay, this is what you are trying to say here.
No, first of all, I'm insisting on this thing that Arson himself was in the car. Number first. Number second, even if we accept your argument that it was not arson, it was his driver, still arson is liable. According to law, still he is liable. Why? Because I told you the maxims, respondent superior and qui facit per alium facit per se. He who acts through another is like he acted himself.
I would like to say here he still hasn't proven guilty. On the other hand, if I take my driver's testimony, he already stated that he was driving in a limited control. Okay, and one more thing I would like to mention here, my lord, that while Mr. Harsh was mentioning or giving the testimony, he also mentioned that there was a bump in the car in front. Okay, so I don't understand that how the collision happened to get the bump in front of the car. Okay. So, and the driver was the one who got the impact and his hand was injured. So, I clearly want to state here that it was the driver who was driving, not Mr. Arson.
Counsel at plaintiff, counsel at defendant. That will be the end of the objection raised. And the court will now resume the proceedings in a calm and respectful manner. No more interruption will be tolerated and you will be directed to desist. Said so, the argument, cross argument, examination, all have been pertained as well as recorded by the jury at EL Courthouse. So Dr. Nikhil Vyas, you may step down of the witness box. And now the court would like to address the counsel from the defendant to please present your witness to the witness box. You may call them up. A small brief introduction given by the witness should be described to the audience, to the court as well. Yes, so defendant, the counsel defendant, Advocate Leaf, Advocate Viedo, you may present your first witness in the witness box. You may proceed.
Thanks, Your Honor. I would like to invite Miss Ria, manager of Mr. Arson.
Ria, you may proceed to the witness box. And the cross-examination from the defendant shall begin now.
I solemnly affirm that I will speak the truth, the whole truth, and nothing but the truth. Your Lordship, my name is Ria Kapoor, personal manager to Arsenal for 5 years. On the night of September 5th, 2025, at 2:15 a.m., I was on a video call with Arsen and I was discussing his upcoming film shoot. He was at home. He was not driving. Her chauffeur handled the vehicle that night. You may check phone logs, Exhibit G1, and it confirms this that I was on video call with him, and that's my testimony.
Thank you, Ms. Ria. So, to you, my question is this, that based on Exhibit D1, how does the video call timing prove my client was not driving during the accident?
Your Lordship, the call log shows up that we speak from 2:15 a.m. to 2:45 a.m., exactly overlapping the crash time. And Arsen was visible on the video at home, calm and focused on work, and he was not in the car. And it is supporting that he wasn't involved in this tragedy.
Thank you so much, Ms. Ria. So, Your Honor, the witness clearly says that she was on video call with my client, Mr. Arson, and she could clearly see that he was not in the car but at his home from 2:15 a.m. to 2:45 a.m., which clearly indicates that my client was not driving the car and was not present at the crime scene. Thank you, Ms. Ria. And I would like to know, like, how does your observation of Arson's routine further establish her alibi in this hit and run case?
As his manager, I know Arsen rarely. I know Arsen, and he rarely drives due to her celebrity schedule and paparazzi risk. That night, he confirmed the chauffeur was handling the earnets, which were aligned with the evidence and proves her innocence.
Thank you so much. So, Your
So,
Honor,
Your Honor,
yeah, this was from the witness, which clearly indicates that my client doesn't drive often, and at that day he was not driving. That's all.
The court has recorded the witnesses' opinions and testimony, as well as the alibi is now with the audience as well. Audience can also verify from their side. I would like to call upon the court will now initiate with the defendant's cross-examination to what the hearing made by the counsel at defendant. So counsel at plaintiff, you may begin with your cross-examination, and the counsel at the counsel at defendant, you may proceed with any objections if any pertained. Counsel at plaintiff, you may begin.
So, Miss Moon, I have a question to you. Like, you had a conversation for 30 minutes till midnight. What was the reason? What was the topic which was shared? Can you tell me?
as I have clearly mentioned that we were discussing about some film shoot.
Can you name specific that which film shoot you were discussing about? And for sure, it is not a private conversation. So you can explain it in broad way that what was the name of the film and what you were discussing, and so that we can cross verify it later.
As I have clearly mentioned, we were discussing. We haven't decided, and we were just discussing few scenes. We haven't
I, ob-
decided the name.
I object,
So how
my
can
lord.
you?
Order in the court. The court reminds the counsel again to please follow the courtroom's etiquettes at all and given time. To the counsel at defendant, you may proceed with your objection once the cross-examination ends from the defendant's, from the plaintiff's side. So objection overruled can be sustained later. You may proceed, Advocate Ram, with your
Yeah.
cross-examination. Yes.
Thank you, Your Honor. So I want to, one point to be noted that a conversation is going for 30 minutes at midnight regarding the film, that what rules should be done, and Miss Moon don't even is aware about that what was the name of the movie, what was the name of the scene, what was the discussion going on. For 30 minutes they were just deciding that what discussion they are going to have, what a conversation is having at the midnight. Can you be more can you be more specific that uh, can you uh, can you be now my question is different. Can you be sure that the driver of Mr. Arshan was not at the home and was gone somewhere else? Can you tell me, and where he was gone, what was the motive? Can you share that?
Okay, since a year ago, uh, we noticed some things which we need to highlight from our film. So we were just making the script for some scene. It was on rape. So we haven't decided the film name, but we decided the scene, that how the thing started, and we just want to highlight this thing in those scripts. So that was the first day of the discussion for that film. So how in the first day, how can we decide the name of the film? Is it possible? No, it's not. And it's up to us that whether we are going to decide the name of the film on the first day or on the last day. It's totally up to us. Then how can you object that uh, we are discussing at midnight for 30 minutes and we don't even know the name of the film? How you can object?
I'm totally satisfied with your this answer. Can you be more? Can you reveal that what was your awareness regarding the driver at that time during that conversation? What was? Were you aware that the driver was not at home, and were you aware of any information regarding the driver, that where he is or where he was at
No,
that moment?
how could I know? I was discussing with film shoot. How why will I ask him some personal question that where is your driver, where's your maid, where's your guard? Why will I ask these questions? So I don't know anything about the driver.
Can I conclude that you were not aware about the driver, that where he was and what he was doing during that conversation?
Definitely.
2.2.
I'm only
Okay,
aware
so
about Mr. Arson. He was on video call with me.
I'm totally satisfied with your answer, and no more questions.
Since the court has mentioned there was an objection was overruled by the time at the time of the response, the advocate from defendant, you may now proceed with your objection. Objection has been sustained. 2 minutes in the court. Ram, advocate from the counsel from plaintiff as well as the defendant counsel, advocate leave. You may begin with your contention.
Thank you. Thank you, my lordship. So I want to ask, like, what is going on? I mean, since my opposition is asking about personal conversation going for 30 minutes, I mean, it's understandable, right? When a person is telling that she was on a video call and she was with Mr. Arson, at that time it specifies that Mr. Arson was at his home, right? And since Mr. Arson was at his home, he cannot be present at that moment when the accident happened. What's your take on this, Mr. Ram?
Yeah, ma'am, you are an advocate, and I think you should be aware that if any claim, testimony, or any witness can't be treated as God, that whatever they are saying is true, we need to verify them. And the conversation was not private; it was regarding in film movies and script making. So it's my duty to cross verify to find out the truth. I was doing that duty. Did I
It's
did
all
anything
right.
wrong?
No, not at all, sir. How could you? But my question wasn't like that. What I wanted to understand was that do you think that since Mr. Arson was at his home, that means he couldn't be present at the crime scene? Since that was the allegation put by your side. That was the only question. Nothing to do
Uh,
with this.
it is not proven yet, ma'am, that arson was at the home or not. There are various witnesses which have seen something similar to arson. And moreover, how can you rely that the information given by Miss Ria is valid? She is the friend of arson. Obviously, it's the duty of the friend to support the person. That's why she might be lying. She is not an authentic witness. She is having a good relationship with the actor, with the accused, and that's why I don't trust the person who is a part of a friendship as a valid witness or a valid evidence. She's not a valid evidence to the court.
Indeed, emotions can betray, I understand, but do you believe in proofs? We already shared that, we already shared the screenshot of video call and also stated very clearly that according to the phone log, Mr. Arson was talking to Miss Ria Kapoor at that time on video call, and from Miss Ria Kapoor's conversation, it is stated that he cannot be present there, right? And since you said one more thing, you cannot trust on the testimonies of the witnesses. I can say that you're 50 meters away witness was also the one who stated Mr. Arson was driving at that time. And this whole conversation makes me feel that we shouldn't trust your witness as well here because it was 50 meters away, and I'm also giving you proof here with the screenshot.
The questioning regarding my witness is irrelevant because the objection is regarding that why I'm asking the question regarding what film she was producing. The objection is that. So you should stuck to that objection. I think you agree that your objection was not valid. And if you do, so
I
we
don't
can move on
understand why it is necessary to know what film they are producing for this
to
particular
cross verify.
case.
To cross verify whether Shreya is saying the truth or lie. To verify that. That was the
Okay,
point. And
if you
if you
say
agree
so.
with that, we can move on to the next thing. You want to discuss about the phone and the witnesses which I have shared. So we can move on. Like you can you I think if you are satisfied with your objection, we can move on.
Yes, yes, totally.
Objection has been now revoked again. So both the side of the contentions were correct. The responses are noted and recorded by the court, by the jury. Said so, we will now again reflect and ask the counsel at plaintiff. You are given one more opportunity to please present your second witness to the witness box. I'll repeat. If you have any, please respond now and call out your second witness to the witness box. The counsel at plaintiff, would you like to respond? Advocate
Um,
Advocate Ram.
yeah, the my witness is missing that. She is hospitalized, that's why she can't come. Someone shoot her.
The court has recorded and will conduct a personalized investigation into this. Advocate Ram, would you like to state your your witness's testimony if you have any?
Yeah, yes. Okay, yes, I had noted the testimony of my witness, and she is Ria, and she is the live eyewitness of the incident. She said, let me quote, Your Lordship, my name is Ria, a delivery worker in Mumbai. On the night of September 5, 2025, at around 2:30 a.m. On approx on Linking Road, Bandra, I was with my colleague when a white luxury SUV sped towards us at high speed. I struck him throwing him on the throwing him on the ground. The driver, which was an Arsan, and which was matching with arson descriptions, looked out briefly, but then accelerated away without stopping or helping. I called the police immediately. That's my testimony, Your Honor.
So the court
And
has, yes, the court has
and
now
sorry.
the written testimony of the delivery worker. Since it's a written testimony and the witness is not readily available due to the proceedings described by Advocate Ram that she has been shot, which Ram you have to provide to the court the evidence to that. It can be a medical report, and the court will give you 24 hours to the next hearing. That will be our responding hearing to provide us with the medical report. In the meantime, if the defendant counsel has any questions pertaining to this session, they can now proceed with their question. If not, we will move ahead with our next witness. So the advocate to raise any doubts, any questions. Cross-examination is now open.
My Lordship, I would like to rehear once more what was the testimony of missing witness, if possible.
Request sustained. Ram, you may proceed with the witness testimony once. It will be just once, and Advocate Leaf, you may begin with your cross-examination questions. Remember, the questions, the examinations that will be responded by Advocate Ram will be his opinion according to the testimony. You may
Thank you so
follow
much.
up.
So, Your Lordship, my name is Ryan, a delivery worker in Mumbai. On the night of September 5, 2025, at around 2:30 a.m. approx, on Linking Road, Bandra, I was with my colleague when a wide luxury SUV sped toward us at high speed. It struck him directly, throwing him at the ground. The driver was a guy matching with Mr. Arson description, looked out briefly, but then accelerated away without stopping or helping. I called the police immediately. That's my testimony, Your Honor.
The testimony has been heard by the court. The advocate at the counsel defendant, would you like to ask or raise any cross-examination questions? You may proceed with that.
No objection, my Lord.
The court has heard, and we shall proceed with our next witness. Thank you so much, Ram, for providing us with the testimony of the unavailable witness, Ms. Priya. So the now court will again be open for our last witness that can be presented by the defendant. Defendant, you may proceed with your witness to the witness box. Please address the examination questions, and then the plaintiff advocates may begin with their examinations. So, Advocate Leave, Advocate Viedo, you may proceed.
Okay, from my side, I would like to call Mr. Arson.
Mr. Arsan, you may proceed to the witness box. Also to mention to the audience with their conscience, Mr. Arson is the predicted culprit into this case. So the defendant, this will be your final witness to present, as well as the plaintiff, this will be your final moment in this courthouse to revoke the opposition. You may begin with your side of conclusion. Advocate Leaf, up to you. You may proceed.
Okay. Mr. Arson, can you clearly tell me what happened that day, especially from the time 2 to 2:15 to 2:45? Where were you and what were you doing?
Your Lordship, I am Arsan, a film actor based in Mumbai. On the night of September 5, 2025, I was at my home on a video call with my manager about a film project. I was not driving my SUV. My driver was handling an errand, and I had no knowledge of any accident until later. I deeply regret the victim's injury, but maintain my innocence. That's my testimony. And about the timing, Your Lordship, I was at my residence in Bandra from 2 a.m. onwards on a video call with my manager discussing the script changes.
Okay. So, since according to opposition, there is always stated that there was one SUV car which is registered under your name, and that car has terribly hit a person and ran away. Do you have any idea about it? And do you want to share something about this whole incident?
Yes, Your Lordship. When that night my driver was handling my SUV, and when he hit that car, he panicked and he ran away. He did call me, and I told him to file an FIR, which is Harsh, Sub-Inspector Harsh Rawat mentioned, and we even have a FIR copy of that thing. And I guess it's just a false allegations on me to bring me down, my reputation, to bring down my career. That's all, my lord.
Okay. Thank you, Mr. Arson, for clearly telling and clearly letting us know where were you and what were you are doing. Since you, since you also agreed that it was your car which was present at that time, but it wasn't you. Okay, so we got that.
Yes, it was my car, and my driver was driving it. But when he called me about this incident, I strictly told him to go to a police station or call a police station and file an FIR, and he even did. Yes.
So the court has now retrieved all the records from the culprit, arson, into the case from the defendant, and it clearly states that arson, with the evidence right now, wasn't there. Opening for another discussion and cross verification for the counsel at plaintiff, you guys are given one more last chance to have a cross examination in your proceedings with arson being the culprit in this case. So, Advocate Ram, Advocate Basit, you may proceed with your cross examination with arson.
Okay. Thank you, Your Honor. My question will be regarding the Mr. Arson, that when your driver informed you regarding the accident which he has done.
Yes, my driver informed me this incident at 3 a.m.
Okay. And what you were doing at that time? You were doing conversation with Ria that time, right?
Yes, I was on a video call, but I can pick the call.
Oh, okay. So at 3 a.m. you cut the call and you picked the call of your driver, right? And he actually told you. What can you remember the exact lines which was spoken by the driver?
He was totally panicking that time, and yes, I can pick the call. I mean, I'm a famous celebrity, Mr. Lawyer. I have more than one phone. And when he called me, he was totally panicking, and he was not even in state of speaking. But as he has worked for me for about like last 3 or 4 years, I don't remember. So I told him relax, and he told me everything. Like he has hit into a car, and I told him to file an FIR, and he even did. And I especially asked him to go to a medical or a doctor for medical checkup, and he did. And we have a medical report as well, in which it's clearly mentioned that uh, his hand was totally bruised because he was holding the steering wheel too hard, and because he was driving the car that time, I was not.
Yeah, really, that's very grateful of you that you told him to go to the police station, but he called you at 3 a.m., which you are agreeing. You means you cut the call of Ria and then you picked the call of the driver at 3 a.m. When the accident happened, like what was the exact time of accident? Did the driver call instantly, um, or did he wasted some time? What do you think?
I didn't get your question. I didn't get your
Yeah.
question.
Did the driver wasted some time after the accident, or did he instantly call you that, sir, what to do?
As I have clearly mentioned, he was panicking, and he called me at 3 a.m.
Okay, but
So it's clearly mentioned.
why he wasted too much time? Like at 2:38 a.m. the accident happened as per the CCTV footage, and then he's calling you at 3 a.m. So why is it so? And you said he was panicked, but he's saying that he was not panicked. He applied the brakes. He gave first aid or supported um, the victim. So what is the truth? Can you be clarified that what he told you exactly?
About panicking, I mean, pressing the brakes is a reflex action, right? If you are in a car and it's getting hit by someone, you will press the brakes, right? So it's a reflex action, and it has nothing to do with the panicking, right? And he was panicking. That's why he was like not in a state, in a situation or a state to call or to tell someone, because he was not even able to grasp everything, what's happened and everything, right? What had
Yeah.
happened.
Okay, so you are too rich. Just for curiosity, I'm asking you. Even admitted also that you have more than one phones. So I just want to know that how is this celebrity life? How many actually phones you have?
Um, I have about like two devices. One is for my office work, and another one is for my personal.
Okay, so you were talking about that what script the writer has wrote for you with Miss Ria at 3 a.m., right? Till the time the conversation was going, and after that you received the call of your driver. So what was conversation going on? Like who was the
Uh,
writer of that script?
Actually, the thing we were talking about the script, like we had some ideas and we were just thinking about, we were just talking and discussing about it. The things which I can't mention here
Um,
in
okay,
public.
but like one,
And there is a one thing that I wanna ask you,
you can ask like.
Mr. Advocate, I would like to ask you one question.
Yeah, you can ask me then.
Mr. Arson, your voice is not
I'm
audible.
audible?
Yes, you're audible now. Yes, you're audible now. You may proceed with your question.
Come
Yes.
on. Okay, thank you so much for confirming. Actually, there was a network glitch. So my question for you, Ram, is that you said your eyewitness, what was her name? She called the police, but according to the testimony of the sub-inspector Harsh Rawat, he said there were only two FIR reports. So it's a clearly mentioned the eyewitness you're talking about. It's just a false allegation, or just it's not true, I would say, because if she had called the police, there will be three FIR reports. But the sub-inspector Harsh Rawat mentioned there were only two FIR reports. So how can you verify this thing? Like, why there were not 3 FIR if she had called the police about this thing?
Okay, so first thing, FIR, application, and the phone call are different things. And I'm not obliged to explain you that these things, but I'm telling you that first information report, then the application which you do complain, and the phone call. These are different things. And many times even I myself call emergency number. Once a beautiful lady was saying hello, and I said sorry, wrong number. So calling the police is not doesn't mean that it's FIR. And this is not the contradiction, but one contradiction I want to mention, that your means colleague, your friend Ria mentioned that she was discussing about a script which was made by director, and you are talking about that you were making the script. So if once there is a contradiction, what do you think on it?
Okay, so you're talking about the phone calls, right? Then why didn't the sub-inspector Harsh Rawat mention that there was he also got another call from a person in the night? So
Mr.
I guess
Arsan,
if
you
he had
are
received
accused, not a advocate, and if your advocates
out,
wants to object, they can object. But the question is simple: that
hear me
you,
out.
Order in the court, Advocate Ram, if you have contended a question to the culprit here, you may give him the optimal amount of time to respond. I will repeat, please follow the court's courtesy and let him finish his answer first. Arson, you may continue with your question, with your proceedings.
Thank you, Lordship. So your question was about the script, right? Yes, we were discussing about the script, and which is totally private, which I can't mention it here, and Ria as well. So the director, manager, and me, we all discuss the script together, right? I mean, suppose if we are like working on a movie, he must have the director must have the script, and he will give it to us, and we will uh, discuss about it, right? So that's what it happened. And another thing about the FIR report that you have talked, right? If she had called, like in my knowledge, if she had called, the sub-inspector might have told us about this thing. Like she has also received another call from a person about this incident, but he didn't mention it here, right? So that's what it happened.
Order in
Okay,
the court,
am I?
Advocate Ram and culprit Arson. Advocate Ram, that is, you have bounded to some certain limits of question. You may stand back and return to your bench. If
Am I
there
audible?
is any objection that has to be raised from any side of the jury, you may proceed.
Um, my lordship, I want to ask for the permission to come up with come with more evidence in front of the court.
The court has to providently discuss it once with the Chief Justice, EL Justice Dinesh and EL Justice Saksham. So give the court a 20-second mark. The court will return to you if we can proceed with one last evidence. Since the evidence mark was in the beginning of round 1, let us have a discussion. Thank you.
Thank you so much.
So order in the court. The judges have returned with their response to the counsel for asking for one last evidence, and you may proceed with your evidence, advocate leave, but you have to state where you found the evidence from. If there's a testimony to it, you have to respond to that as well. And also, this will be our last part of witness round. So make sure not more than 2 objections should be raised from the plaintiff counsel, if any. And that's also a contention of question. You may proceed with that, advocate leave from the defendant.
Thank you so much, your lordship. So, for the last proof and evidence, I would like to tell my position about life of the celebrity. They need protection, okay? They need security. And for that purpose, sometimes they also plant CCTV cameras in front of their home and sometimes even in their home, right? So I would come up with the concrete evidence that at that time, when the case happened, the person who was driving the car was not Mr. Arson, and he was in his house at that time when the accident happened. Hereby, on the behalf of my fellow partner, lawyer Ms. Viado, I would be sharing the evidence with the court and the judges. And in order to tell the court that how I have obtained this evidence, it took me time, but I would like to call upon the next hearing. The reason being is because the person, like there are workers, and at the very moment, none of the workers in testimony is here so far. So if the court allowed us one more hearing, then we would present the person who works in the house of Mr. Arson, and he was present at the time when Mr. Arson was on the call doing some cleaning and all.
So the court would like to re-verify that you have shared one more evidence. Knowing the fact that the evidence selection was over, the court proceeded with your evidence, yet there are no provident, if I'm not mistaken, if the court is not mistaken, there is no evident testimony that you have received. I'll repeat, if there is no testimony regarding the evidences provided to the court and to the audience, advocate leave, we might have to call the evidence an overrule, as well as a paramount to not being discussed in this court. I'll repeat again, if you have a testimony, if Arson, the culprit, wants to continue with the testimony that he holds the guarantee for this CCTV, we may proceed with the hearing for this, else we may move to our next round.
Thank you so much, Your Lordship. And here I would like to call Mr. Arson to present his testimony and yes, to verify that this footage is from his house and it is taken from his CCTV system.
Yes, my lord. It's me sitting in my house under a CCTV camera. It's a CCTV footage of me talking with my manager, as you can see.
So the court would like to repeat this again, that in whole conscious, the culprit, the witness in this round, Arson, has taken full guaranteed, as well as he states that this evidence is provided by his proficient testimony. The court has recorded the well said, and I would like to open the objection or discussion from the advocates from the plaintiff. If you have any doubts regarding it, not more than 3 objections can be raised, and you can easily communicate to the witness current, Arson. So the advocates at plaintiff, you may begin with your final verdict as well as your final examination.
All right, so I would like to have few questions. Number first question is I would like to have evidence from my adversary on the point that which I already mentioned before this court, that the arson, the celebrity has more than one mobile phones, has more than one cell phone. So this proved my point that it's not that if a mobile phone belongs to you, it is always with you. This is number first. I would like to have the evidence. I would like to have the evidence from my adversary. That is the call logs of both the mobile phones. This is number first. Number second is my question is that Arson contradicted when he said at 3 a.m. the video call was going on. This is contrary. This is totally repugnant to what Ria said. Ria said that they concluded, they ended, they terminated the VC, they terminated the video call or whatever they were doing at 2:45 of the clock, 2:45 a.m. So this is a contradiction. Please, Your Honor, take note of this. And number second is about the script. Arson said that director gave them the script and they were discussing on that. But Ria said that they were creating their script. These are the arguments which I have, and if my adversary cares to explain these things, please.
May I speak, my lord?
The court has first noted the contradicting statements as stated by the advocate Basit, and Arson, it will be your only chance from this onward to repulse. If there's any contradiction that can be cleared out, this is the last chance for you. Court,
Okay.
you may
Thank you so
proceed
much,
with
my
your-
lord.
Yes.
Thank you so much, my lord. I would like to ask my lawyer to answer these questions.
Since the witness has already mentioned that he would like to proceed on not on his behalf but the behalf of the lawyer, the court will ask advocate leave to proceed with the hearing then. And the advocate Basit, advocate Ram, you may then continue with the objections for the next 2 minutes, not more than that, 2 minutes with advocate leave. You may proceed with the objections.
Thank you, my lord. So I would like to state for the very first question two contact phones. That is the objection. That is the claim that is being brought by my objection. So I would like to state earlier as well there were phone log history, radar history, CCTV screenshot, but objection denied to accept that as a concrete proof. Hence, we have presented the CCTV here, CCTV footage to be precise, or a click of a CCTV footage. For the second question about Ria's testimony, court doesn't run on words, but it needs proof. If you have any concrete proof that whatever Ria is whatever Ria has stated so far is accurate, then I would like you to present a concrete proof on the behalf.
Okay, so I want to mention these two things that Ria stated 2 points that the conversation was during 2:15 a.m. to 2:45 a.m. That was the Ria's statement. Second, Ria's statement was that the 1 year ago they noted something and it was regarding rape scene and they were making the script. They were the actor. They were making the script. That was the Ria's statement. To so that it is wrong, it is not valuable. The arson contradicting it said that at 3 a.m. I cut the call of Ria, video call of Ria, and picked the call of driver. If the conversation already ended at quarter to 3 a.m., then why the conversation is arson is cutting the call at 3 a.m.? That itself proves that the whole story is a lie. It is contradictory to itself. Second point, that Arson said that director gave them the script and they were discussing about it. which itself is contradictory to the statement of Ria. Both the statement of Ria and Arsons are contradicting itself. It proves that both Ria and Arson never did homework about how to lie in front of the court. Do you agree, Miss Levy, regarding it? My question is regarding, can you please tell me the specific time through which the conversation between Arson and Ria was going on? Because both of they are lying. They are telling the wrong numbers. I think the case is over.
Yes, the advocate from the defendant, you have been raised a question. Would you like to respond to that, or shall the court begin with its next proceedings?
I would like to respond.
You may respond.
Okay, so about the question, sir, again and again you are coming up with the same very thing I have stated. If you have any proof which proves that Mr. Arson was the one who was driving the car, apart from the testimony which does not have any proof about the delivery girl, I would like you to come up with the proof, okay, the concrete one, and share it with all of us and court. Let the court see that you have the proof that Mr. Arson was the face sitting on the seat driving the car and hence the accident happened. I have nothing more to say about it.
We will move towards that also, but let me tell you, do you agree that both Arson and Ria was lying? Or do you agree that there was no phone conversation going on? And if not, then tell me the time of the conversation which was going on. Tell me the time. And this is the time. And tell me what was the actual time when this image was shot. Can you be specific the image which you have shown where the Arson was having conversation? What is the time of that? Um, I'm seeing it is AI generated, what I think.
My lord, I have no, I don't wish to answer any more questions since the position is only just putting some assumptions and coming up with false accusations and not giving any kind of proof, neither real nor fake. At least they are, trying to come up with fake. They are telling that we are presenting the fake proof, but they are not coming up with any proof, with just some words. And I believe I no longer can go with the answer.
Do you think that, okay, my question to you is, okay,
Order in the court. Since the lawyer from the defendant had already mentioned that there should be no bogus communication and no bogus convincements made from the other side, Advocate Ram, you may return to your bench, and said so. Advocate Leave, you to please return to your bench. And that marks the end and conclusion of this part of the trial. So the court appreciates the diligent and the dignified efforts of both the parties in representing the evidences, the arguments with utmost professionalism. Every piece of testimony, every document, and each legal submission has been carefully considered. Now it is the court's duty to weigh the fact against the law impartially and deliver a judgment grounded in justice. This process ensures fairness prevails, that the truth as supported by evidence guide our verdict. So I thank the counsel, the witness, and all the court staff as well as the audience for their cooperation and dedication throughout these proceedings. The judgment will be pronounced in due course after thorough deliberation. Said so, let's proceed with the closing remarks from the advocates, beginning with the counsel at the plaintiff. You will be given 2 minutes for your closing remarks. This will be your final point to verdict. And similar for the counsel at a defendant. Advocate Ram, Advocate Basit, you may come up forward with your closing remarks.
All right, Your Honor, I would like to conclude this proceedings now by mentioning some points. So, at the start of this trial, we told you a simple story. We put the facts before you. So, from few things I told you, for example, actus non facitrium nisi mens citria. This was a hit and run case. Arson did not help the victim to get him hospitalized, and he ran away from the spot. So this was actus non facitrium nisi mens citria and res ipsa locutor. Both were corresponding to this. Number second is the CCTV footage, which although was grainy, but it never ever coverts, it never disguises the model of the car, the fancy number of this car. That is very obvious from the CCTV footage. Another point is the forensic science laboratory says paint chips from the victim's clothing are identical to those from the accused's car. Next point is the eyewitnesses which were summoned before this honorable court. And one more point I would like here to share is that forensic science is more reliable when the results are 100% true. That is more reliable and should be admissible in the court of law and should be given more weight than any other eyewitness. If not eyewitness, but witness in general, I would say. Moreover, I mentioned before this court that there were contradictions in the arson statement and in Ria's statements. Ria is the eyewitness is the testimony of the defendant's side. So for that, I have a maxim. We say that falsus in uno, falsus in omnibus, which means false in one thing means false in everything. So we cannot rely on the mechanics eyewitness and totally disregarding the forensic science this results. They are more reliable. And Locard's principle, that is the principle of exchange. The paint was identical to the accused's car. So the adversary could not provide the phone calls from both the cell phones. She could not provide the call logs which I asked for. So yes, I would say that arson is guilty, and even if it was his driver, the driver was working under his guidance, he was working under his employment. So first of all, we believe that it was arson himself. Although we could not make it clear whether it was arson or not, but the adversary also could not make it very much clear due to the contradictions in Ria's statements and Arson's statement that it was not arson. None of us could prove this. And from the call logs, I would say it was arson himself. And justice is due. I would say he is culpable, he is guilty, and should be sent behind the bars. And let the justice be done. Thank you very much.
The court has now heard, recorded, and reported all the incidents, all the points at the end mentioned by Advocate Basit, representing the counsel from plaintiff. The court extends the gratitude for your presence, and now the court invites our final closing speech, closing remarks from the Advocate Viado, representing the counsel from the defendant. So, Ms. Viado, Advocate Viado, you may proceed.
Thank you. Your Lordship, when we examine the totality of evidence, it becomes unmistakably clear that my client, Mr. Arson, could not have been involved in the alleged incident. Why? Because the lane driving report confirms proper driving behavior, directly contradicting any claims of rash or negligent driving. And there is this FIR which contains glaring gaps and inconsistencies, which we have already shared. And it determined the reliability of the prosecution's version. The health report shows my client sustained no injuries, something entirely inconsistent with the alleged collision. And most importantly, the verified call logs, which we already shared, screenshots irrefutably prove that my client was at home on a call with his manager discussing work at the exact time of the incident. And this establishes a firm alibi. And even when the other side explains the CCTV footage, which the prosecution may rely on, it does not show my client at the scene. While it captures the model of the car, of course, it cannot confirm the identity of the driver. Similarly, the eyewitness testimony is weak at best. Why? Because they were over 50 meters away and could not have positively identified my client. Taken together, these evidences, the lane driving report, FIR, call records, health report, and the weaknesses of the CCTV and eyewitnesses' accounts, it clearly shows that beyond reasonable doubt that my client was not present and had no involvement. So we respectfully submit that the charges against him be dismissed and he be fully exonerated. Thank you.
So, with this, both the defendant counsel and the counsel for the plaintiff have stated all the evidences substaining to the case. All the arguments are being recorded to the court, and now the court can make its final judgment. So, thank you to the learned counsel. Your detailed and compelling closing arguments were heard and recorded as well. It is the duty of the court to carefully consider all that has been presented in accordance with the law and to deliver a just verdict based solely on the facts and applicable legal principles. I remind all the parties that the standard of proof in this case rests with the prosecution, which must establish guilt before a reasonable doubt. Now, the defense, meanwhile, is entitled to presumption of innocence unless proven the otherwise. I'll repeat again, the court will now take this time to deliberate thoughtfully. The judgment will be pronounced on a future date dated 14th of September 2025. I'll repeat, the judgment will be pronounced on a future date of 14th of September 2025, which is considered tomorrow, which will be notified to all concerned. Until then, the court stands its adjourned, said so, coming from the EL Chief Justice Dinesh Sir, EL Chief Justice D. Saksham. The court is now officially adjourned for the day.
Okay, since we have finally completed the event very successfully, I would like to give a vote of thanks to one and only Saksham. Why so? Because he single-handedly managed everything, each and everything. And to everyone who is not aware about it, he did not sleep throughout the day, maybe just 1 or 2 hours. And even for that, he was regretting, why did I even sleep? He handled each and everything. I know other people also contributed, but he's someone who was taking care of each and everything. And I don't think that I can appreciate him enough. It was very visible that how hardworking he is and how much efforts he, put into all these things. And it was such a new idea. I know, like, we kind of messed it up at times, but I believe that it will be huge success in coming days. And even now, it was one of the amazing sessions that I was a part in. So thank you so much, Saksham. I cannot emphasize on it that how much I appreciate your efforts, and I believe that others does too, because you manage judging part, organizing part, and formatting everything. I cannot even name the things that you have done. So again, huge thanks to you and to everybody else who is involved. But since like he carried the most of the weightage, so I'm taking his name. But it's not like that I'm neglecting other people's efforts. So even Shirley, her name is Liv now. She's having an examination on Monday. Still, she managed to take part, and to manage things with me. Even I was like, okay, I am not prepared. And Arson was like, okay, I'll just accept that I have done it. So all these things were going on. Moon and Harsh, Nandan, and everybody else who was a part of it. I'm so sorry if I'll forget anyone's name, but you guys did an amazing job. So congratulations to all of you and to all of us. Yeah, that's it.
Um, I would also like to say something like, honestly, what a fantabulous idea. Like, it was so complex when I was just going through the whole format. I thought, it needs lots of efforts. Like, all the evidences, all the things which were posted, it's not easy to make it. And Saksham, you did it. I know you went through a hell lot of a time. You need to work extra hard. You also sacrifice lots of night to make it. But believe me, it's one of the most challenging, most interesting, and like crazy kind of event which you have pulled it off on this platform. And thank you so much for the efforts and everything. You also motivated me somewhere. I mean, not in a cozy way, but you just went with solving all my problems. That was one of the things which you did. Thank you so much. Apart from that, I would like to give a shout out to Patricia. Like, she was also one of the person who was back. I mean, working at the back. She was making posters on this one poster which is there on my PFP. Pretty good. Like, it's really good. Okay, she was there. Leo Patrick, he was also there, though I don't know how much he contributed. And at last, my team, like, you know what, Weirdo was there, and she made me feel that, yeah, I can pull it off. She encouraged me. I was very nervous. I also did big blunder at the very starting, but I really enjoyed this whole event. Thank you. And apart from that, Arson, he was so cooperative, even though he was the main highlight of the story. But he was so cooperative. Like, he really wanted to win this case. It was truly his case, I believe. So thank you so much for this whole event, everybody who was involved.
I want to say one thing that no matter how much the opponent defender can praise the judge will give the justice. They are not going to let the criminal escape the prison. Tomorrow, the real culprit will be punished. This is from my side.
Since it ended,
Oh,
I
Ram,
say
it
you put.
wasn't about it. I mean, we were not trying to, take the attention on ourselves and like, okay, since we are saying good words to them and they'll, make nothing like that. And thank you so much, Shirley, for mentioning Patricia's name. I thought everything was made by Saksham only. This time she was busy, I guess, but I was not aware about it. So yeah, huge thanks to her. And so sorry, I forgot Denise's name since he did not speak much. So yeah, thanks to you as well for giving us your time, and it was very complex and you made it. I know you are also busy in your work, but still you were here judging and listening to all the crap that we did. So thank you so much. Yes, but sorry, Shirley, over to you. You were saying something.
No, I was just saying that since the case ended, everything ended, you can put Sakta, you can put arson in jail. I don't mind. Go for it.
This is not ended. Tomorrow is the hearing.
If they found me guilty, they're gonna hang me. Okay.
Yeah, I would also say something about this beautiful session. Uh, like, yeah, someone was talking about Saksham. Like, literally, I have worked with him. Not much, but at least for this special session. So Saksham really worked hard and gave everything for this. As we all were not aware of the moot courts pattern, it was something which was very unique for us. We were having it for the very first time. So, and I have hardly seen people putting so much efforts for something. And I would also say something when it comes to working, he works really very hard. And when it comes to giving credits, then he becomes a true leader. So not only for him, but for the whole organization, English Learners Organization. I feel literally very proud, and I take pride being in such a special group. So this was a new session that we all have witnessed today. Thanks to the English Learners Organization, everyone. Thank you, everyone, for bringing this up.
All right. Good night, everyone. Good night, all of you.